All right. Sounds like we're in good shape. All right, I'm going to call this meeting of the Business Law Survey Commission to order on February the 4th, 2026. Do we need to do a roll call, Mr. Willis?
According to the bylaws.
Okay, do we know who's here? We've looked around the room. It looks like Mr. Gutwein, Mr. Enright, Mr. Hollingsworth, Mr. Sullivan are here. Mr. Macaluso, Ms. Monroe, myself, and that is Mr. Barrett is on virtual. And then we have a variety of guests that I'm sure you will note in the minutes for us.
Yes, sir.
Okay, and so let's turn first to the minutes of October 29th of 2025. Are there any additions or corrections to the minutes?
No.
Hearing none, I will entertain a motion for approval of the minutes. So moved by Mr. Macaluso. Is there a second? Second by Ms. Monroe. All in favor, say aye.
Aye.
Any
Aye.
opposed? No opposition. So that passes. They're approved. And now I will turn it to Secretary Morales for some comments.
Thank you, Mr. Chairman. Good afternoon. It's great to be here at another Business Law Survey Commission meeting today. As you know, I have not missed a meeting. And I want to start by saying thank you for your continued work to ensure Indiana remains a national leader in business law. As we start off 2026, our Business Services Division remains focused on core goals: achieving better connectivity, stronger fraud prevention, and continued modernization. First, connectivity. In January alone, just last month, Indiana saw more than 9,300 new business formations. That's a lot if you ask me. And we made real progress in improving contact with governing persons, especially those registered agents. That's a strong start of the year. Second, fraud prevention. Through enhanced technology and hands-on review, our business services team blocked 460 fraudulent businesses formations in 2025, preventing bad actors from entering the Secretary of State's records and protecting both businesses and Hoosiers. And modernization. Last year, we migrated all the Secretary of State systems to Amazon Web Services, creating a secure, innovative infrastructure. We also launched a Captain Records, an AI-powered system managing millions of achieved records. Finally, we remain committed to working with this commission and the General Assembly on issues that will continue making Indiana a business-friendly state. I recently was in DC attending the National Association of Secretaries of State Conference, where I was making sure everyone knows Indiana and everyone knows that Indiana is open for business. And of course, bragging to other secretaries from across the country about our Indiana Hoosier football team. My team and I continue to attend and congratulate new businesses that are opening across our state. We're attending ribbon cuttings, groundbreaking ceremonies, anniversaries. Each milestone is making our state stronger. I want to sincerely thank every single one of you for your continued leadership and partnership as we make progress on these priorities. I look forward to today's meeting and to what we will accomplish together for Indiana's business community. Mr. Chairman.
Thank you very much, Mr. Secretary. Keegan.
So I will give a short update. Obviously, we are in the middle of legislative session, past the halfway point. Unlike previous years, there is no break this year. They're going straight through with the goal to finish around the third week of February. So about 3 weeks left of session at this point. So pretty quick. So at the beginning of session, we met with Representative Snow, or prior to session, we met with Representative Snow on both the ICBL proposed changes and the tax clearance changes. We anticipated him authoring those changes in one of his bills that he had Those did not make it into this legislation. We tried to get it in on second reading. And sadly, because it sort of is a omnibus bigger bill, there were other things that made it in on that first half. So we are working with Senator Scott Baldwin in the second half of session. So hopefully those pieces can get into the bill he's carrying over in the Senate. So hopefully we can get those in a bill and across the finish line. They don't seem to be any issues with them. We've worked closely with the chamber. They've been involved in some meetings. Josh Hollingsworth has been nice to attend a meeting with Representative Snow as well. So stakeholders are involved, making the legislators know these aren't complicated issues. They're pretty common sense, and then make Indiana a more competitive business environment state. So that is my update there. In terms of new members, we're still waiting on approval from the governor's office. So that is where that stands.
Okay, there's a couple other things listed in there. Do we have anything to say about the Indy Chamber or?
Like I said, the Indiana Chamber has been very open to working with us on changes to the ICBL. And I think over the next year, they may actually take a more deeper dive into Indiana business law to see if we can have some more comprehensive updates. I don't know what they're thinking about, but that's just what they've said in a few meetings that we've had with them.
Okay.
And I spoke to them this morning as well, Mr. Chairman.
Okay. Very good. Mr. Willis, UCC.
As far as the UCC update, I met with Mr. Barrett and Mr. Sullivan and discussed their thoughts on the harmonization. Back in December, they gave me some good input. We're really at a point where we're trying to finalize the NBIS updates as far as the modernization of our tool to make sure that we can handle whatever updates that we may suggest, especially, taking everything to full online filing. And so I'll probably will not be able to give a firm date on that and for another month or two till we get all that technology integrated and make sure we can actually do it.
Okay. All right. Well, then there are no questions for him on that. Then let's move into our old business. The operating rules. There's two things that I would like to do with respect to the operating rules. Janet, Keegan and I, or Keaton rather, and I need to sit down and go through them sort of page by page. But in the meantime, I guess I would be interested if anybody has any particular thoughts on things that need to be changed other than the quorum issue, which we're going to discuss in a minute, and participation issue. And if you do, I would suggest that you email us in the next, couple of weeks and let us know what thoughts you have. And so I guess the sort of preliminary assignment is if you have not read those operating rules recently, I would suggest that you do so, because every time I read them, I see something else interesting in them. So if you see anything that you think we ought to talk about or needs to be changed, let one of the three of us know, please. The second issue is there are at least two sections in our current operating rules that we may need to deal with sooner rather than in connection with the entire package. One is the requirement in section 1-8 that each member of the commission must physically attend at least one meeting of the commission annually. And then the other one is section 5(1)(b) that says 1/3 of the members must be physically present at the place where the meeting is conducted. I guess the question is, obviously, those probably need to be changed. I'm assuming that maybe, well, I guess, what thoughts do you have about how those ought to be changed? I mean, my thought on the one about being physically present for at least one meeting, it might be sufficient to say that you must be present for one meeting, which would include virtual present, because if you're not going to attend any meetings, there's really no point in your being on the commission. But I'm not sure that we're still in a state of affairs in society where it's necessary that you actually present yourself in the same room as everybody else. As Janet said, I think COVID has taught us that maybe that's not necessary. So my thought would be to just strike the word physically from that. The other one about the quorum, I don't know. I mean, do people think that there is a particular advantage to having a certain core of people in one room and then everybody else can attend virtually, or does that not matter?
I speak up. Mr. Chairman, I appreciate your comments, but I'm one of those guys that, if I take responsibility to be part of a board and commission, I must show up physically and be part of that board and commission. To give you an example, I signed up to be Secretary of State. I arrive most days at 5 a.m. We open at 7 a.m. every single morning, which I'm proud of that. So respectfully, I don't think it's a good idea to strike that word physically. I think if we want to be part of the board, we need to obviously make a commitment to do that. So that's my 2 cents.
Okay, other thoughts? Yeah, Frank.
Mr. Chairman, I sort of analyzed the second issue the same way that you analyzed the first, that COVID changed the way we all do business. I'm also sensitive to the fact that I work right across the street from this building. It's pretty easy for me to be present. So we are a statewide commission. And I think that to facilitate participation from our members who are not local, having pretty much the same rule for quorum as for individual attendance would make sense.
Okay. Well, I guess.
I have a thought. I think the statute that talks about physical presence predates any of the changes that we went through during COVID, and moreover predates, therefore, the changes to the statute or the changes to the general rules or that we've seen in other boards and commissions and at local governments around the state. I don't know that there's much of a reason for us to depart from that. I certainly agree with the concept that if you're not going to appear, there's no reason for you to be on the commission, and that failure to appear over a course of time would in essence violate your appointment. I don't agree that it needs to be in person. And I say that because I'm the one on Zoom today. Usually I'm there, but today I can't make it. But I agree with Professor Sullivan that we ought to be cognizant of the world we live in now, both technologically and geographically.
I should clarify on that. Obviously, we meet 4 times a year, right? So you may go on vacation, you get sick, you're ill, anything happen. Of course, you can join Zoom.
Excuse me.
At least we need to make an attempt to at least join 2 meetings out of the 4 physically. And the other 2, hey, you're on vacation. Okay. You don't have to call us if you're on the beach, right? So, but that's just for clarification.
Okay, any other thoughts?
I think I'm in the camp of encouraging people to attend in person whenever possible, but not having it as a formal requirement.
Okay. Well, I guess sort of in the sort of pivoting slightly on looking ahead for April to see whether we need to change this before April. Is there any reason that I should anticipate that, on April the 1st, that we won't have at least a third of the members in person on that date here, that we would need to change this before then so that we would have a legal meeting? I mean, we obviously, the weather is terribly cold outside, and we managed to get at least a third of the people here today. So my inclination is to say that this is probably not something we need to vote on today, because we'll probably be okay in April. And then if we can come up with a change, a proposed change in the operating rules by then perhaps we can we can adopt them all in one big shot.
I plan to be there in person in April.
Okay.
Same.
All right.
April Fool's Day.
Yeah, that's right, you know.
Right. I'll come on
Okay.
March 31st, just to be safe.
Well, then I think what the plan will be that we will try to have a draft of amendments to the operating rules for our April meeting so that we can adopt some changes then that align with people's views on all this. Mr. Jim? Yes.
One quick thing, if there is to be in the bylaws some type of a provision on attending at least one meeting a year. I want to give some thought to whether you want that to be a calendar year or on a rolling basis, 1 or 4 meetings, something like that.
Okay, yeah, I think that's a good thought.
I don't know that I have a view on that, but it's.
Yeah.
That comes up from time to time when you have an annual attendance.
Yeah. I think that we have not had a problem with that recently. I do recall some time ago, some significant time ago, that we had to have a conversation with someone who was officially a member of the commission that some of us had never seen. And it was time for that person to resign. So there probably is some value to this, but exactly what it should be, I think we can talk about. So, all right, that will be the plan. Hub meta changes. How are we on that, Frank? Can we put something together for that by April, you think, or?
Yes, sir, I will.
Okay.
We've been waiting for quite some time for the Uniform Law Commission to put out its final report, but there have been some things on a project that they've been working on, and but there's some other things that happened even before that project that we probably ought to give our attention to. So if that's not forthcoming, I'll bring up to, and we might want to look at some of those changes.
Okay, sure.
Too. But the timing is right because we want to get that circulated and vetted if we were to hope to go to the legislature.
Sure, okay. And then I guess we're still in the middle of the comment process with the LLC Act, right?
Yeah, but I finally made some real progress on that. I
Okay.
hope to have some things around here very I had to do some research and it took me a while to remember how to do that. I finally did. And we'll have something around that we had a working group on that, have something
Right.
around with that probably.
Okay, okay,
Thanks for your indulgence.
no problem. Okay, now then the other big issue would be the nonprofit corporation statute task force. I've had some people that have approached me or Scott Willis and suggested that they're interested in doing that. I have names. If you are not sure whether you've told one of us and you want to be involved in that, please let me know. I think that at least for the time being, I will chair that task force and then try to get me a co-chair that I can get to do most of the work of getting people moving and organized. But I think that we will get started on that and try to get something that is based on the most recent version of the Model Nonprofit Corporation Act, the ABA's version of our IBCL, and see if we can get that put together in time for maybe our meeting in the fall, so that we can get it into the hopper for the 2027 legislative session. Yes, sir.
And would you have any interest? I don't know whether there would be interest, but there might be some interest both at the law school and at the School of Philanthropy in being involved in some way in this project. And I don't know that there would be, but I know we teach you know, of course, it's not from business law or law school. I personally don't. And, I know there's a lot of part of the curriculum over at that Lilly School of Philanthropy is paying attention to the legal structural requirements of not-for-profit organizations, and might be some interest there, be a way to share the workload a little bit.
Yep. My view is that I would love to have as many constituencies as we can get involved in this task force. So my thought is,
I'd be happy to look into that if you'd like.
okay,
Yeah.
that would be great. And since most of these task force meetings end up happening by Zoom or something else, there's no problem getting people.
Physical presence.
Generally, no, although you're welcome, because if you have physical presence, you might get to eat. I also know that in our minutes we talked about, there was an interest by somebody, I think it might have been the State Bar Association, or somebody had a group that was interested in that, and they may want to send a representative. I don't know if the Amy Chamber has an interest in, you know, connecting up with that. There's gonna be some, I think, as Josh found too, I think there's some people that are not on the commission that are lawyers in various places that we may want to bring into the fold in order to do some of the work on it, so that all of us old folks don't have to spend a lot of time relearning how to do research. So I think, yeah, I believe that as many people as we can get involved in it on at least on a serious basis or an occasional basis would be great. So any ideas you have along those lines, and as I said, if you want to be sure that you're on the list, let me know. If not, I may draft you at some later date if we find we even need more people involved. But I'm hoping that this can proceed pretty smoothly so that we can have something, we can share something with you in the interim meetings, and then have something, you know, that's pretty ready by the fall. So.
Is there anyone that's familiar with that? It's called, I think it's called Charitable Allies. It's a nonprofit law firm that only serves nonprofits.
One of my students is there. In
Oh.
fact, I had that same thought.
It would be a
Former students.
resource.
I reached out to Robert Miller. He's with them.
Same guy.
Yeah, and he said he would be interested in helping out. So they specialize in that or
Okay,
focus on
get
that. So
us his contact
I will.
information, and we will include him.
He was a very fine student.
Okay, very good.
here's my intro.
Okay.
Oh, is that right?
First name.
Any other comments on that subject? All right, let's move on to new business and other projects. And before we get into that, Josh raised an issue with a bill that's currently in the legislature that we might want to discuss for just a minute. Do you want to talk a little bit about
I don't
that?
know a lot of, I'm hoping my colleague Mike told us. I understand Mike involved, but I don't know. I found out about this morning. Any interest, Bill, are you up to speed on that? Or you-
I am,
Can you-
as is Bill.
Okay, okay. I was not aware of this. I thought it might be, are you able to? maybe-
Yeah, sure. I'd be glad to talk about it. It's called the Uniform Antitrust Pre-Merger Notification Act. It's a product of the Uniform Law Commission, which I think everybody's generally aware of, is the organization of representatives of states that get together and have as their mission trying to identify areas of law where uniformity from state to state would be advantageous, but where we don't want Congress telling us what to do. And each state has a delegation that has been appointed pursuant to statute. Well, at least in Indiana, pursuant to statute, that works on these projects over a number of years. And it's much like the legislative process here, the various stakeholders work on it over a series of years. And I'll get to the substance of this in a minute, but I think the background that it's a uniform act is important here. And Indiana has been a very heavy adopter of uniform acts. I counted up times in excess of 7, believe it or not. everything, and you've worked with a lot of them, Uniform Partnership Act, Uniform Limited Partnership Act, a lot of them in the family law area. But Indiana has a group of representatives who go off to the Uniform Law Commission. And I could speak in shorthand and say that they range from Frank Sullivan to Jim Bob. And with Bill Barrett in between.
Somewhere between.
And it is really as non-ideological as anything I've ever been involved in. And I should say here, this is a very significant, I say with the American Law Institute, these are the two leading law reform organizations in the country. And I say this for a different reason. Bill Barrett is on a leadership ladder to become the president of the Uniform Law Commission in a couple of years here. This is a significant professional honor and a great tribute to our state. And we're all very, very proud of Bill and the work he's done in the commission. Back to the substance of this. The Federal Sherman Act, as modified by the Hart-Scott-Rodino Act, gives states the opportunity to intervene in federal antitrust matters. And in fact, one of the most famous antitrust cases of all, Ohio versus American Express, is a case where the state of Ohio, rather than the Justice Department or the Federal Trade Commission, got involved. The problem under current law is there's no standardized procedure for state attorneys general to get information on pending transactions. And if they want to get involved, they often have to do so by litigating. It's clear there is US Supreme Court precedent. It is clear that they're entitled to the materials, but litigation is a mess. As Bob Ronald was talking when I worked at the law firm in which you now work, litigation is no damn good. And so the idea here was that there was a need for a rational process whereby state attorneys general could get information on mergers that they might want to look at, in which their state had an interest, but that had all of the confidentiality protections that the current filings do. When a merger transaction under federal law requires a Hart-Scott-Rodino filing, those materials are kept strictly confidential until the companies themselves decide to announce their transaction, if they ever do. The same confidentiality, so this bill provides a mechanism for states to get Hart-Scott-Rodino filings if they have a sufficient enough interest in the matter. Sufficient enough interest being defined as either they have their principal business in the state, or they have more than 20% of the threshold amount of the Hart-Scott-Rodino filing amount in the state. And only those states, they'd be required to make a filing within 1 day of that. And then all of the confidentiality protections that apply at the federal level would also apply to the state attorney general's office. In the course of California considering this law, the telecommunication, the cell phone industry became concerned that the confidentiality protections were not robust enough. And so in the course of negotiating the bill in California, more robust confidentiality requirements were added to it. And those confidentiality requirements were amended into our bill on second reading last week before last. The bill passed the Senate last week, I think 47-0, and has been referred to the Judiciary Committee, where its chair, Representative Jeter, is the House sponsor of the bill. Bill and I have both been involved in this, and he may want to add something to what I've said.
No, I can't improve on that at all, Frank, except to say that it's a very salutary, and although it's not necessarily directly within the purview of this body, it'll be good for the state.
Thanks for doing.
Okay. The limited partnership and general partnership statutes, we've talked about this for a long time. And I guess what I would like to do is, I don't know if people have further comments they want to make here, or whether I can just suggest that is you go back to your various organizations you work for and ask around and see whether there is enough interest that this is something that we ought to actually put on the list for. I think we may have enough to do this year, but is this something that we ought to put on the list for the 2028 session, which would be our work in 2027? Or have limited partnerships and general partnerships fallen so far off the radar, or down, at least down in priority, that it's not something that we need to really spend a lot of time focusing on? I don't presume to know the answer to that question. I know that we've gotten some statistics from Scott Willis in the past, which suggests that there are not a lot of filings in Indiana on these. And while on the one hand, general partnerships are sort of the default that people that don't figure out what kind of business they want end up being, and there may be some virtue in updating that statute for that purpose. I also know that, on the other end of the scale, when you come to larger organizations that might care about some of these things a lot, Indiana is probably not their first choice to file. It's going to be Delaware or Wyoming or something like that. So, I mean, the pressure is not necessarily on for us to do something about that. I know Frank would be very much interested in having us adopt the Uniform Acts on this.
Well, these are both uniform acts. The General Partnership Act, I think we have the Uniform Act of 1818 that's never updated it. And we do not have the most recent version of the Uniform Limited Partnership Act, although there are probably more states that have not adopted that than have. But I think what Alan says about the General Partnership, about the General Partnership Act sort of being this baseline for a lot of times, I wouldn't say a lot of time, but from time to time, people are deemed to be general partners. There was a very interesting Indiana case on that just a few years ago called Wolf against Agro. And it does seem that having those modern rules, if people were to find themselves in that position, having the most modern rules on the books would be to our advantage. I think we would want to say, wouldn't we, that even if we were to do both of these, that we would want to grandfather in any entity that was formed under, maybe we even have to, as a matter of constitutional law, grandfather in anybody who was formed under the earlier statute, unless they opted in. As I say, both of these are uniform acts, and a lot of good thinkers put in a lot of time and effort in developing these new concepts, and probably most people in law school learn more modern concepts than you realize that are under the old statutes. But it's certainly true that these are forms that are not used very often. I was here to think about this. The LLP statute is sort of the second half of the general partnership statute and incorporates by reference in it a lot of what goes before. And that might, and there are a lot of LLPs around and being formed. Pretty much everybody in this room is part of it. And And that might be a way on, Mr. Chairman, of looking at it, is to say, are these really the rules, default rules that we want for our law firm? And answering that question might give us some idea as to whether this would be a useful thing to do or not.
Okay. Well, if people have further thoughts about this, why don't we plan on in April when we meet to try to decide what our plan is with respect to these, whether that's something we want to put on the docket for the beginning of next year, or whether one or both of those. I guess the sort of related question, if you looked at the bottom of the agenda, we've had update the business trust statute down there for years. And I'm not sure exactly whether there's any reason to think about that, or whether it's just been there because it's been carried over and carried over and carried over. And so I guess I'd be interested in whether anybody has any thoughts about that. I'm in all my years of practice, I have never formed a business trust that I'm aware of, and I don't know anybody that has, I don't think. And so I guess my question is that something we ought to be looking at or thinking about, or is that just something that should stay on the bottom of our agenda, and when we're out of things to do, then maybe we worry about that? I don't know. I just throw that out there, because it seems like there's some virtue in sort of making a plan for where we're going with some stuff, and just keeping it on the bottom of our agenda for the next 3 or 4 or 5 years may not make a whole lot of sense.
I'm not sure that makes a whole lot of sense to spend time and effort on the business trust statute. I do think it makes sense to look at the general or uniform revised Employment Partnership Act. So those are materially different, and people find themselves in those accidentally. I'm less concerned about law firms that have pretty robust partnership agreements, and more about the two people that go into business for themselves and find themselves in a partnership, and the revised act is much more specific on how things get treated. So.
Okay. All right. Well, we'll put that on the agenda to just figure out what we're doing in April. And then going from potentially further down the road to nearer down the road, as far as other projects, I've talked to Josh, and I think that he is going to, once we've gotten these IBCL comment or changes taken care of, he's going to take a look at the PC statute to see if there's things that need to be done there in order to conform it to what we've now done to the IBCL over the last several years. And see if I don't even know if is there a uniform PC statute, or does the ABA have a model PC statute? I don't know where that one came from exactly. But I think that Josh is going to get his task force maybe to take a look at that, and spend a brief period of time on that. Maybe they can give us a little report on at least what their initial thoughts when we get together in April. Okay. Any other thoughts, concerns, things people would like to bring up at the meeting today? Yes, sir.
First, say that the two of our members here were amici in a recent case decided by the Indiana Supreme Court, and the position that they brought to the court was sufficient to overcome a textualist interpretation of the statute and prevail. And one of your partners was also on that brief.
Oh, okay.
It's a very interesting. I speak of a case called Nemeth Properties against Panzeca. And the question was whether a LLC operating agreement must be in Indiana. And the answer advocated by our colleagues was yes. Supreme Court 5-0, so that.
Okay. Very good. Anything else? Are there any any members of the public who would like to make public comments at this meeting? Okay. If not, then our plan is to have our next meeting on April the 1st. I know that there seemed to be a division of opinion about whether it would be better to try to get all of the meetings scheduled for the year immediately at the beginning of the year, or whether people's schedules were too fluid down in the second half of the year. Maybe the plan should be that in April, we will try to get the last two meetings of the year scheduled so that we know what we're planning to do and people can get it on their calendars. So we will do that. So come prepared to tell Scott when you can and cannot meet later in the year. With that, I will entertain yes, sir.
I wanted to mention one thing. I believe in the operating agreement, it mentions the annual meeting occurs in September. If you
Yes,
Want that to stay the same, then
I suspect we will probably propose changing that to the final meeting of the year. And so that we won't have to worry about what, I mean, right now it says it'll be in September unless the chairman says otherwise, which is, personally empowering, but I'm not sure that's necessarily the best thing to have in there. Okay, I would entertain a motion to adjourn. Second, all in favor, say aye. All right,
Aye.
I will see you on April the 1st.